Good afternoon, everybody. I'd like to welcome you to Medmarc's final webinar of the year, Litigation and Claims Trends for the Life Sciences Industry. My name is Andy Hall. I'm a Senior Claims Examiner here at Medmarc, and I'll be your moderator today. This year we've modified the format here a little bit, and we're going to be presenting using a moderator panelist format, which we hope you will find beneficial. Before we dive into the substance, I want to introduce our panelists. Our first panelist is Sonia Valdes, who's Medmarc's Vice President of Claims. Among many other things, Sonia is responsible for managing the claims team here at Medmarc. She has decades of experience in claims and in the life sciences industry in particular. She is a frequent speaker and panelist on issues related to insurance claims in the life science industry. Our second panelist is Pamela Ferguson, who is a partner in the San Francisco office of Lewis Brisbois. She is also the Vice Chair of the Products Liability, Class Action, and Mass Tort and Life Sciences practices. She is a litigator whose practice focuses on the defense of complex multi-party litigation that includes drugs and medical devices. Our final panelist is Kelly Waters. Kelly is a partner in the New York office of Wood, Smith, Henning, and Berman, as well as the managing partner of the New Jersey office. She is a litigator whose products liability experience includes years of experience defending pharmaceutical and medical device companies. Kelly also serves as a municipal court judge in 2 New Jersey municipalities. Going over the agenda here real quickly, we want to cover a variety of areas, kind of give you an overview here, including litigation and claims trends, case law trends, regulatory roundup, update on mass torts, and then we're going to spend some time talking about future trends. So with that, Pamela, I know each of your folks are interested in hearing about the latest important verdicts in the life sciences arena. To get us started, can you tell us about some of these verdicts in the 2019 period?
Sure. Thank you, Andy. It's been a pretty traumatic year from the defense perspective in terms of the verdicts that we've seen coming down. And I want to overview with our audience some of the reasons why we think the verdicts, and particularly the punitive damages awards, have been in the area that we see it in. If we look at the next slide, some of the issues are the public distrust of big corporation, which plaintiffs' firms are really latching onto as a theory of liability. Obviously, when we defend these cases, we're not just defending the product. When it comes to punitive damages, you get into the deeds of the company, and the trend appears to be plaintiffs argue to the jury that the developer of the product lied at the research and development phase with the resultant clearance that was a fraud on the FDA, even though those types of claims would be precluded under federal preemption. They argue that there was a deception even at the research and development stage, which resulted in approval being given for a product that really wasn't fit for market. And we've seen that in a number of the bigger verdicts that we'll touch on a little later. Attention span of juries, in the next slide, actually, this slide is taken off True Law's website. True Law is a firm out of Illinois and Missouri who have scored pretty big verdicts against Johnson & Johnson in the talc litigation, which we'll talk about as well. But I thought this slide was interesting in terms of the focus from the plaintiff's bar, that they will argue the development, the costs of development to Big Pharma, the lobbying costs, and the amount that they spend in drug lobbyists translates into trillions of dollars in revenue for them. So when you put that kind of a backdrop up against the jury, $1 million is chump change. And so they really do get into this failure to report side effects to the FDA of any adverse events that have happened with the drug or the device. And that in turn translates into this threat of punitives, which has manifested itself in a number of cases that we'll review in a little bit more detail. One of the factors I think that we face, one of the most problems we face as defense counsel, is that the juries invariably have made their own mind up long before you get up on your feet to do your openings. Part of the reasons for that is the millennial jurors, and in the next slide we see a somewhat humorous depiction of the attention span of the jury being less than that of a goldfish currently. I think that has been somewhat questioned, the underlying data for that statistic of 9 seconds being or that your average juror has less than 8 seconds attention span has been called into question. But I do know from personal experience that when I started practicing here in the 1990s, I was told I had 24 seconds to make an impression on the jury. And, being Irish, we're not known for fast talking, but certainly made me try to rush to the end of my openings in that case. It's a lot more dismaying now to see that has whittled yet again. And I think there's a direct correlation between dwindling attention spans and all of the gadgets that are demanding our attention, including social media, and everything has to happen in less than a New York minute, when a New York minute used to be the pressure point for all of us. I think this is also borne out by one of the highest verdicts that came out of Georgia recently in the trucking world, where a jury delivered a verdict of $280 million on a premises liability inside of 45 minutes. Now, most defense trial lawyers in the audience would expect when your jury comes back that fast, they're usually coming in with a defense verdict, so that had to be something of a shock. If we go to the next slide, it'll show, I like this one for perspective purposes. This came from the RAND Corporation, and it's a study of jury verdicts, punitive damages awards from 1985 to 1994. And if you look at the amounts, there were 15 jurisdictions that were studied for this particular study. 20% of the verdicts were resulted in an award of punitive damages. The majority of those were in business and in the intentional torts arena. Strangely enough, product liability back in the day only accounted for 2% of the punitive damages awards. I think when you look at the judicial hellhole report that was recently issued by the American Tort Reform Foundation, nearly all of the huge verdicts are coming in the life sciences arena, so that's pretty troubling. I did check to see if the RAND had any current data, but I couldn't find any. I suspect that they probably can't keep up with the verdicts that are coming out. But certainly the American tort reform did cover a lot of the judicial hellholes that we call them, or judicial gold mines if you're on the plaintiff's bar. So I would like to talk to you about some of the examples of the punitive verdicts that we've seen. Risperdal, I've included Monsanto Roundup, even though it's not truly in the life sciences space, but I do think these high verdicts are shaping the landscape and setting a platform for jurors to, be desensitized to awarding billions of dollars in punitive damages. The other area I want to talk to you about a little bit is the talc and the IVC. So if we turn to slide 8, and the Philadelphia largest verdict coming out of Philadelphia, which, by the way, is now #1 as a judicial hellhole, California having ceded its place to Philadelphia, not because of anything good that's going on in California, but because Philadelphia has just gotten progressively worse. So Risperdal is a drug that was approved by the FDA for treatment of schizophrenia in adults, and it was marketed aggressively to treat children with autism. It hadn't then been approved by the FDA for that purpose and was being used in that way in what we call an off-label manner. So the jury believed the plaintiff's line of attack, again, that there had been reckless ignoring of the risks associated with it and underreporting of those risks and bad acts on behalf of the company. the award is grossly disproportionate with the initial compensation that was awarded in the case. $680,000 were awarded to a plaintiff who's from Maryland. And I think this case, again, is evidence of the success that plaintiffs have when they forum shop and when they land these coordinated proceedings or MDLs in the judicial hellholes like Philadelphia. It also was based on a complete disassociation of the scientific evidence. There's lots of data suggesting that there was no statistically significant connection, and if judges fail to be the gatekeepers of junk science, the verdicts that happen in Risperdal are exactly going to be repeated and repeated and repeated until there's some judicial reform and judges begin to take responsibility for the junk science that the juries are allowed to hear. The original award was $1.75 million, but it was reduced to $680 because the plaintiff was a citizen or a resident of Maryland, and Maryland has caps, so the award was reduced. But $8 billion in the punitive phase was a single plaintiff award, probably one of the highest that certainly I'm aware of. There continues to be, I believe, another 7,000 Risperdal cases in the coordinated proceedings in Philadelphia County. And it's, again, this idea of a young child developing abnormal breast growth, or gynecomastia is what the condition is called, was a reason why the jury went with sympathy over science, and we're seeing that time and time and time again. So it becomes really important to put a face on the company and try to fight back as much as you can on that. So if we go to slide 9, Andy, the next slide. Thank you. There we go. This is a 2005 survey of the Median Damages Award, and I think I put it in purely for historical reflection that in the 2005 median damages by successful plaintiffs, it gives you the breakdown, and you'll see in the medical malpractice arena, the average jury award was $679,000, and in products liability it was $748,000. I think if anyone was to get those types of verdicts today, it would almost be considered a win, particularly when you compare those to the verdicts that are coming down. The following slide just gives you a kind of a sense of comparison of what your demograph looks like, what juries are awarding compared to their own earning capacity and income. This is an old slide as well, and I find it a bit of a struggle to believe that there are any plaintiffs who are earning even close to what they're awarding in damages for these plaintiffs currently. So if we move to the next slide, we're talking about the Roundup litigation. This is one that I think Monsanto had the weed killer that European governments have looked at. They've had many studies done disassociating any causal connection with the ingredient glyphosate or the chemical glyphosate. It's been ruled out as a carcinogen in many, many studies. And again, we're seeing sympathy over science. Monsanto's reputation has really taken a battering because of these lines of cases. They've been banned in the state of Hawaii. They're dubbed as the evil seed of corporate greed, and they're probably on the top 10 list of the most hated companies in America under the Harris study. The first verdict in August of 2018 was reduced. It was $250 million in punitive damages, but reduced to $78 million. In March of 2019, there was a verdict in the Hardiman case. These are all out of California, these decisions that are on your screen. The Hardiman case resulted in a 5.2 compensatory and 75 million in punitive, but that was reduced to 20 million. In May of this year, there was a $55 million compensatory verdict for two plaintiffs in the Piliot case, Alva and Alberta. These were plaintiffs in their 70s who had used the weed killer for decades. They had never used any protective gear or protective clothing while working in their yard. And they really rung the bell heavily with the jury in Alameda Superior Court. $2 billion was awarded in punitive damages, and Judge Smith in Alameda reduced that award to a collective $86.7 million. There was some question in those trials about geofencing and internal documents that cast doubt on the safety of the product. But again, there was no firm scientific evidence to support the causation. And ultimately, what you see in these cases is the plaintiffs ignore the causation and just look at liability. And if there's evidence of bad acts on behalf of the company, or if the plaintiffs can put on a good story and tell the story well, that there were lies, or create the veneer or impression that there was less candor than should have been with respect to these cases and the risks associated with the product, then I think there are problems associated with that, and the jury will ultimately find in favor of the plaintiffs because of the sympathy vote. There is an 800-strong MDL with 11,000 cases in courts across the country, and from that verdict came out, the number has increased to 42,700 plaintiffs. So you can see that the plaintiffs bar are actively canvassing for these cases, and that, at least with respect to Roundup, it's a fair indication that midnight TV is still worth the haul. Moving on to the talcum powder cases, this slide is again from the True Law website, and it actually shows the impact of the excessive damages that we've seen in the talc arena. Bear in mind that, again, for decades, Johnson & Johnson was able to defend the theories that talc had caused or that there was asbestos in talc and that it was capable of causing epithelial ovarian cancer. Along comes Mark Lanier, a very famous plaintiff's lawyer, and he gets the largest verdict in 2018 with a $4.7 billion verdict for 22 women out of Missouri. The Missouri judge affirmed that verdict in August of this year. The verdict caused the stock of Johnson & Johnson to tank by about $50 billion. There was $50 billion in stock market loss value by the Friday after that verdict came out. So this slide, I think, the True Law team are, really espousing what they can do to companies and, the bragging rights that they have for these types of large verdicts and the impact on the company itself. And they do that for a reason, to bring the companies to the negotiating table rather than appeal against the verdict and try and reduce it in settlement negotiations post-verdict. By the way, the first talc case was tried in 2009, and they offered $1.3 million to settle confidentially, but the plaintiff in that really balked at the idea that she would have a gag order and not be able to talk about these verdicts or the risks associated with the talcum powder, and she rejected it. She ended up going to trial, and the jury found liability but didn't award her any damages. It was a very strange case indeed. But that, as I say, was 2009, and we were in a much different market now. There are 15,500 talcum cases, talcum powder lawsuits pending against Johnson & Johnson, according to their SEC filing. It's not just that you're up against the sympathy over science, but you're also up against the judges, and the Judicial Hellhole report that came out talked about just that. In the Johnson & Johnson September 2019 verdict, where $40 million was awarded in plaintiff's verdict, the judge struck the defense's closing argument. So you really, I mean, when jurors are seeing those types of instructions from the bench, it clearly has an influence, and I'm certain that it will loom large in the post-trial motion. Because in that case, with $40 million, the jury didn't find that Johnson & Johnson had negligently designed or sold its talc, or that the company acted with malice or fraud. And yet they give this really excessive, probably one of the highest talcum awards up until that point. So the 4.69 billion award from the Missouri jury to 22 women is exactly what fuels the jet engines of the plaintiff's bar. And I think, you know, unless the judges are going to take a better hand, you're dealing with these types of verdicts. They're splashed all over social media. The jurors are desensitized to the verdicts, and as a result, you know, you're fighting an uphill battle before you even get on your feet with opening arguments. I want to turn very quickly to the IVC Filters litigation, because it again has had a mixed bag of successes. There have been many verdicts, defense verdicts in the IVC filter cases. But again, you're in these judicial hellholes like Philadelphia, where recently there was an award of $3.4 million with a $30.3 million in punitive damages. I have to say that was something sinister, in that it's exactly 9 times the compensatory amount of in punitive damages. The yardstick is anything over 10 is excessive. There's case law, the BMW, State Farm, Campbell, all of those say that you cannot have a double digits award of punitive damages that offends the due process and conscionability of the Constitution. But here we have a jury who's not just applying sympathy over science, but they are also now savvy enough to realize from social media, from whatever source, that they are in a world where single-digit punitive damages will not get overturned on appeal, and that's exactly what we have in this one. I will tell you that in that case, the jury was attempted to be polled. They didn't. Plaintiffs made the case in the Philadelphia case that the manufacturer had lied to the FDA, and that they'd lied on technical data that wasn't provided in pre-market approval process, such that the approval that they ended up getting to take their device to market really, it should never have been approved. And so you juxtapose that with a judge who is allowing all the evidentiary issues to come in, not marshalling the evidence, not granting any of the defense motions at the pretrial stage, and allowing plaintiffs to pretty much say heinous things about the developer and the doctors. They even allowed evidence of another separate clinical trial not involved in this product at all to come in before the jury on a failure to obtain the exemption to try a device in clinical trials. And that resulted, unfortunately, for the developer in that particular clinical trial, of him losing his license in the state of Washington. So the jury heard all of that, and as a result, they lashed out with the punitive damages award, not believing that the company was bona fide or reliable. So those are all part of the post-trial motions, but as part of that, I think it's illustrative in the way that juries are now looking at corporate America. And I think Sonia is going to provide you with some other reasons as to why we're seeing these very difficult and extraordinary verdicts.
Yeah, thank you, Pamela. Sonia, can you give us some additional factors that you think are leading to these vengeful verdicts?
Sure. I think another factor playing into these large verdicts is the negative publicity and the negative view of the FDA, which ironically coincides with the new administration, the Donald Trump administration, which made it one of its principal goals is to speed up approvals and to cut red tape. Part of the objection to the mammoth 21st Century Cures bill, which also, again, aims to expedite the approval of drugs and devices, increase approved products, but it's also very favorable in terms of a brain initiative study concussion, a cancer moonshot. It has a lot of really wonderful things associated with it, but most people, most of the legislators that are running for re-election are saying that it is terrible for the American public. It's very unfavorable because it really just puts profits over what they argue to be safety. And this has been the mantra of Elizabeth Warren and those who have looked at the 21st Century Cures. So I think that was the beginning of some of the criticism of the FDA. So we heard that in the beginning of 2018. 2019, it continues. It's been open hunting season on the medical device industry. They've been attacked on several fronts in legal cases, but also in print and television media. I've outlined some of the more notorious ones up there. One was an actual documentary. The other one was it's a fairly prominent book, New York Times bestseller. All agree, all of the arguments, the publishers of these books, is that the critics argue that the FDA is too cozy with the medical device industry that it regulates, and frankly, the trend does not appear to be abating. In my opinion, the industry's response to these attacks has been woeful. The head of the Trade Association for Medical Devices described as leading edge, as entertainment, and gave it no credence. Unfortunately, I don't think the public the public at large views these articles or documentary as entertainment. These are the people who sit on our juries. I want to shift gears because a lot of us have already heard what's happening to medical devices, but the drug manufacturers and distributors are not immune from some of the negative publicity. Prescription drugs are somewhat trailing medical devices in terms of bad publicity, but they are catching up. Generic drugs are big business, almost an insatiable need throughout the world for these generic drugs. Catherine Evan, a noted author, attacks the generic industry and describes the corporate fraud and dangerous manufacturing environment at a Ranbaxy plant in India. Ranbaxy was and is a huge international manufacturer of generics used in the U.S. This is a non-fiction account of a whistleblower engineer who was trained at BristolMyers Squibb in the U.S. who could not keep quiet about what he witnessed at this Indian plant. The book details factory workers fleeing from the FDA inspectors with garbage bags full of fraudulent records and a company wiretapping the hotel rooms of regulators strategizing on how to conduct a factory inspection. Ranbaxy is also accused of dumping worthless drugs lacking any API into Africa. For its role in an attempt to defraud the FDA, Ranbaxy was fined more than $500 million. China RX is similar and exposes the filthy condition of some of the plants manufacturing generics bound for the U.S. Lastly, Dreamland is an exceptional account of the evolution of the opioid addiction crisis in the U.S., from pill mills to importation of cheap Mexican black tar heroin and the web of distribution around the U.S. The book focuses on Ohio, West Virginia, and Virginia. These are the states and cities' responses to deal with the opioid crisis. So there was another source of unhelpful publicity for the FDA and drug companies, and that was the president himself. About a year ago, the president actually made this statement: drug companies are getting away with murder. It's unfortunate because it wasn't meant literally. It was meant to address drug pricing. The president went to war with drug companies for a while there. He seems to have wandered off a little bit. And he put through the American Patients First strategy, which relies heavily on importation of generics from overseas. And we'll see later that this has its own problems, the importation of overseas generics. So have these outrageous verdicts had an effect on claims, trends, or results? I think I have to say the answer is yes. From a product liability trend, there's less claim frequency but more severity in the U.S. Indeed, this is the state of claims at Medmarc. We've largely avoided the more significant mass torts, and our large cases are really not that large, comparatively speaking. On the product side internationally, we're seeing the opposite effect. More frequency and yet severity has stayed the same. A recent Allianz study reported an increase from 800 to 1,300 claims in Asia, which is about a 61% increase. But what about medical professionals, i.e. med-mal lines of business? For the claims settled under $2 million, which is the average SIR for a hospital, the claims frequency has increased 2%. However, for the number of claims costing more than $5 million, that's increased 15 to 20%, according to a study by Aon. The average indemnity paid for med-mal claims over $5 million has increased from $8.6 million to $10 million. What are accounting for these large settlements and higher indemnity? Similar causes for both areas. From the frequency side, I think tort reform has weeded out the weaker cases, but more problematic issues have arisen. And here's one of the more problematic issues: the quality of the plaintiff that we're seeing on the claim side. We're seeing a number of claimants with underlying health issues. The number of claimants with underlying health issues is increasing. There's a Washington Post article of November 26, 2019, titled, "There's Something Terribly Wrong. Americans are dying young at alarming rates." It discusses the increasing mortality and falling life expectancy for people in the United States from ages 25 to 64, which is not the story internationally. It goes on to describe, for example, obesity. The rate of obesity in 1999 to 2000 was 35.5% of the population. In 2015-2016, that number became 39.6, which is pretty high and pretty shocking. According to the Post article, 71.6% of the population in the U.S. is overweight. A woman now weighs as much as a man did 50 years ago. Moreover, there are implications from obesity. One of the implications is often diabetes. There's been an increase in type 2, the silent killer, which affects circulatory system, eyesight, and cardiac issues. It's been linked to pancreatitis and pancreatic cancer. Painful and complex disease to manage. It affects the claimant's abilities to recover from an incident with a medical device. And what else is an effect of diabetes? Often dialysis. These people have to get the excess sugar out of their blood. So between 1993 and 2013, a 40-year period, there was a 40 times increase in dialysis in the U.S. In 2013, Medicare paid over $34 billion per year for dialysis. That number has already doubled. And as I said before, diabetes and the need for dialysis are associated with obesity. But there's another factor, too, and there are addiction issues with a lot of the plaintiffs that we see. Plaintiffs' addictions to opioids and other drugs requires additional medical services, longer hospital stays, and less successful outcomes. As a country, we are experiencing levels of addictions among the populations that have never been seen. This is a true epidemic. The Post article states that of the 33,000 excess deaths since 2010, over 33% occurred in 4 states: Ohio, Pennsylvania, Kentucky, and Indiana. Not surprisingly, these states are ground zero for opioid addiction. There's also been a rise in cases alleging traumatic brain injury. In more and more cases, plaintiffs are alleging TBI. They're doing this for 2 reasons. It's difficult for the insurance companies to disprove, and it's creating the potential for more medical treatment in terms of doctor visits, higher life care plans, because of the potential for lost wages. Increasing likelihood of the jury finding that there is a permanency of the plaintiff's medical condition. What else is the cause for this higher severity? Healthcare skyrocketing costs. Advisory rates for hospitals are $10,690 per occupied hospital bed per day. The cost of medical treatments or services has outpaced the consumer price index 3.3 to 2.5 for their normal industries. In addition, in many cases, plaintiffs claim there will be future treatment for several years and submit a life care plan. The cost of settling a case with a substantial life care plan can be exorbitant. Settling cases with huge liens due to hospital and medical expenses is also more difficult. Most healthcare insurers are not willing to take deep discounts to negotiate their liens, making it more difficult to settle these cases. From a litigation perspective, causes of social inflation, there's a whole other seminar that we could do in the last couple of days talking about the presence of millennials on the jury, the use of the reptile theory, and the ever-increasing importance of litigation funding. I will say that all of the potential causes of increased case values that I've mentioned from a social inflation perspective, I am most concerned about litigation funding, particularly in the mass tort context. Litigation funding, also known as legal financing, occurs when outside investors front legal fees in exchange for percentage of potential settlements or judgments. With upfront access to funding, claimants may be more inclined to go to trial, refuse a reasonable settlement, or seek more expensive or unnecessary medical treatments. Their attorneys may also pursue more complex legal arguments, all of which can extend litigation and drive up the expenses associated with the litigation. This is here to stay, and there's been very little to do to regulate litigation funding. So I think it's a real problem for us going forward. And so I'll shift gears and let Pamela just take us through case law trends.
Thank you, Sonia. Pamela, if you could give us a little bit of background on the BristolMyers Squibb decision from 2017 relating to personal jurisdiction and kind of what we've seen since that U.S. Supreme Court decision and whether we have any trends that are favorable or unfavorable.
Sure. This is one of the good things that's coming out of California, where in certain jurisdictions we have a judge, probably one of the better judges on the bench, Judge Brad Seligman. He didn't have a great reputation, but he certainly seems to have, acquitted himself with full honors, in my view, because he did apply the BristolMyers Squibb decision to about a class of, or a coordinated proceeding of about 400 plus out-of-state residents who are making a claim that amiodarone, the drug that's approved to treat classical defib but has an off-label use for afibrillation, were not sufficiently connected to the state of California under the BristolMyers Squibb decision. There was a challenge, there were many challenges because the plaintiffs were given leave to amend to try and state a better claim, and they were looking at anchoring their nexus to California for these out-of-state plaintiffs on the contractual relationship between the manufacturers and the distributors with McKesson Corporation, who ultimately had relations with all of these manufacturers, brand manufacturers and generic manufacturers to distribute the drugs for them. And the specific claims that plaintiffs made was the idea that this medication guide had to be given to the plaintiffs. Happily, in our case, the judge rejected that as against all of the weight of evidence and the FDA regulations, Buckman, etc., and applied the BristolMyers Squibb decision. So it's currently up on appeal, but he gave a very solid opinion, and we're hopefully going to see that upheld on appeal. I did notice in the Judicial Hellholes report that the BristolMyers Squibb decision is getting some traction in, I think it was South Dakota, but don't quote me on that. So with respect to California, at any rate, the claims are certainly enjoying a mixed review, I would say. Whether BristolMyers Squibb is applied to mass torts, I think that's a given. Everyone in the circuit is following that decision that personal jurisdictions can be made, determinations of personal jurisdiction can be made in the mass torts, but there's uncertainty when it comes to class actions, and so we're still seeing, California is a big magnet for the filing of class actions, and there's a split in the circuit with the decision that was given out of Central California in May of this year that the court there decided no, BristolMyers Squibb has no application to class actions because of the ability of the class representative to act on behalf of a nationwide class, which is an interesting ruling because we don't believe that, certainly for the consumer protection statutes, there's no extraterritorial application for those. In any event, that's the Sotomayor decision. So just moving to the next slide. I've touched on the Amiodarone case where the appeal is pending. We don't expect it to be overthrown. We have seen on the Innovator Liability side not much change, or certainly the concern that we had initially with Innovator Liability, that it was going to have, a very punitive impact. Innovator liability, essentially, for those who may not be aware of it, is this doctrine that brand name manufacturers, because they were the innovators to the product and they hold the license, that they are responsible for any labeling, warnings, etc., while they continue to hold the ANDA. And they're also been held, the Conte decision held the brand on the hook for the generic manufacturers' drugs in that case. So this was a real eye-opener and a very concerning case that, the plaintiffs thought they could make lots of hay with. But I think the recent decisions, certainly the Mensing decision where federal preemption was held to apply to brands and generics, and the Fosamax ruling have really tempered the decision under the Conte case, and Innovator Liability is not enjoying the success that we initially thought it was going to have. And that in part is due to Herculean efforts on the defense bar and the briefing that they've made in the TH Novartis case.
Thanks, Pamela. I want to kind of keep this moving. So we did have a couple slides on regulatory that will be in the slide deck that we'll move through. But Kelly, can you give us a quick update on mass torts?
So you want me to skip the excise tax, Andy?
Yeah, let's move on to mass torts.
Okay. All right. All right. So we can go to slide 32. One more. Thanks. Hi, good afternoon, everybody. As Pamela shared with us earlier, some of the largest verdicts and settlements in the past year mass torts in the pharmaceuticals and medical device arenas. As we all know, mass torts are civil actions that have many plaintiffs involved against one or several defendant corporations, and these lawsuits can be venued or taking place in state or federal courts or both. Up there, the first heading I have, as of December 2019, just this month, 200 MDLs, which are multi-district litigations, are pending with greater than 20% involving medical devices and pharmaceutical products. Now, I want to just talk briefly about opioids, zantac, and hernia mesh, given that we've heard about the other ones in Pamela's presentation. But MDL is the acronym for, if anybody doesn't know, for multi-district litigation, which seeks to consolidate complex cases so that they're managed by one court. While it is often said that the goal of an MDL is to conserve resources and foster consistent court rulings, I'm sure everybody on this call will agree that it's also an attempt to allow plaintiffs to forum shop. Now, the opioid litigation, In re National Opioid Litigation, is currently venued in the Northern District of Ohio. Approximately 2 years, the judicial panel on MDL litigation transferred all opioid-related litigation pending in federal courts throughout the U.S. to the Northern District of Ohio. Fourth quarter 2019 has seen some significant activity in this litigation. Most notably for this call is the coining of the term negotiating class. Now, in this MDL, there are thousands of cases pending in Ohio, even though there are other municipalities litigating similar opioid-related lawsuits in state courts throughout the U.S. Two noteworthy ones that I'm going to talk about are Connecticut and North Dakota. The defendants include numerous manufacturers, distributors, and pharmacies. So most recently, on November 11th of this year, Judge Daniel Poster certified a negotiating class. Now, for those of you who are familiar or not familiar with the rules of federal rules of civil procedure, negotiation class is nowhere to be found in Rule 23, which governs class actions. However, Judge Foster, in determining about whether or not to certify a class, felt that he needed to overcome an obstacle that he felt existed if the parties were going to move towards settlement. Now, Judge Posner coined the term negotiation class using in part the defendant's need for a global settlement, that is a settlement structure that resolves most, if not all, lawsuits against them arising out of the opioid epidemic. Judge Posner interpreted this need as an obstacle to settlement because in a standard settlement class action, the class members can opt out of the class after the settlement is reached. With thousands of counties and cities already litigating, the defendants in this MDL were very concerned that many of the plaintiffs would opt out. Thus, they would be paying a lot of money to settle non-litigated claims, but would still have to litigate a host of potentially similar, potentially significant claims outside of the class action model. Now, just grab my paper. The idea was to undertake the class certification and opt-out process prior to a settlement being reached, that this would then fix the class side and provide the defendants with a sense of precise scope of the group with whom they were negotiating. Now, the other interesting two takeaways that I would ask you to remember, because this is, again, the first time you're seeing the term negotiation class utilized, but it has the same players of many settlement classes. And when I talk about Connecticut and North Dakota, for an instance, for a minute, you're going to question, why would anybody ever move forward and negotiate? And is this a way to extract additional monies from the defendants? Now, the difference between a traditional class, what I'm using as the term traditional class action, is that after the end of the opt-out period, the class will operate if and only if one or more of the defendants wishes to negotiate with the class as a whole through the negotiation class mechanism. That provision is nowhere to be found in the Rule 23. It's brand new. And while you have to at least give Judge Posner some credit in trying to marshal all of these cases, the question then becomes, is this really something that still requires the plaintiffs to meet all of their obligations under Rule 23, or is it just a way to squeeze more money out of the defendants? Now, the second highlight in this case is that the negotiation class addresses claims brought under the Federal Racketeer Influence and Corrupt Organization Act, commonly referred to as RICO. And the RICO claims first allege that 5 defendants misled physicians and the public about the need for and the addictiveness of prescription opioids, all in an effort to increase sales. The second RICO claim alleges that 8 defendants ignored their responsibility to report and halt suspicious opioid sales, all in an effort to artificially sustain and increase federally set limits or quotas on opioid sales. The third claim that was certified for class resolution is an issue related to the Controlled Substances Act and whether or not defendants were required to create systems to identify, suspend, and report unlawful opioid sales, and that the defendants failed to meet those obligations. As of November, so the claims in the in re opioid litigation are federal RICO and violations of the CSA. As I said earlier, one of the concerns about moving forward in this negotiation class is, or in a class settlement vehicle, is that the defendants don't want to have to go through all of this discovery, attempt to settle, and then have a large percentage of the class opt out. In the 2 state courts, as well as have to litigate municipalities in the state courts. So in this federal lawsuit, there are 34,459 class members as of November 27th of this year. The opt-out period ended on November 22nd of this year, so there is 98% of the municipalities, cities, and counties and states that are in the federal MDL. So we will see, one of the things we're looking at is whether or not this quote-unquote negotiation class is going to have any traction. On the state side, what we see in Connecticut and North Dakota are two cases where the courts granted a defendant's motion to dismiss because the first one in Connecticut, it was brought by the City of New Haven versus Purdue Pharma, and on January 8th of this year, the court found that that if the municipality is suing in an ordinary civil lawsuit, it's not going to survive without proof that the people they are suing directly caused them the financial losses they seek to recoup. So here, it's interesting where the defendants, manufacturers, suppliers, pharmacies, in this case Purdue Pharma, were able to be successful on a motion to dismiss. But one of the distinctions is that it was a consumer fraud and nuisance allegation. And that's also similar to the North Dakota case, where a motion to dismiss was granted, and that occurred on May 10th of this year, finding that the state, in suing Purdue Pharma, was not able to make their burden of proof for similar reasons on their consumer fraud and their nuisance statute. So why is the federal lawsuit able to go forward? Because it's a different cause of action. RICO claims carry treble damages. There might be an incentive from the defendants there to resolve it, especially given that they have 98% or 34,000, almost 35,000 municipalities in that litigation. Moving quickly to Zantac, from a timeline perspective, what we all have heard that Zantac, or the generic version of ranitidine, the active ingredient has a molecular structure that makes it susceptible to naturally creating NDMA once it is ingested. On September 13th of this year, the FDA issued an advisory warning the public of a Zantac cancer risk due to the presence of the NDMA, and within 10 days thereafter, generic drug maker Sandoz and Apotex issued the first recall. A month later, Santa Fe and Dr. Reddy's Labs Ltd. recalled those products, and on October 28th, Perrigo, Novotum Pharma LLC, and Lanet Company also issued a recall. There are currently two Zantac class actions. One was filed on September 13th in the state of California against Santa Fe, alleging concealment of a Zantac cancer risk. And then 1 week later, the same law firm, Hagen Sperman, filed a second class action, New Jersey District Court, on September 19th, accusing Santa Fe and Boehringer Ingelheim of knowingly manufacturing, selling Zantac containing a concealed carcinogen. So again, the Zantac litigation, it'll be interesting to see how they follow government issues of recall, and then you see the litigation thereafter. I don't know if a negotiation class would be utilized in that instance, since these are more personal injury claims as opposed to municipalities looking to recoup the monies that they believe they've paid in connection with addressing the opioid epidemic. Two issues on the hernia mesh litigation. Hernia mesh is implanted surgically, just as a background, to stabilize tissues during an abdominal hernia repair surgery. Annually, there are 800,000 hernia surgeries performed in the U.S., with approximately 90% performed with the surgical mesh. Manufacturers include Ethicon, Atrium Medical, CR Bard, Covidien, Cortex, and Medtronic. As of August of this year, there were 6,800 hernia mesh lawsuits pending in 3 separate MDLs, one against Atrium Medical out of the New Hampshire District Court. First bellwether trial in those cases are going forward February of 2020. There are 3,003 lawsuits against CR Bard over different brands of their polypropylene products. And with respect to Ethicon, as of August in the Georgia Northern District Court, there are 2,300 pending lawsuits over Ethicon's PhysioMesh flexible composite hernia mesh. Additional cases are pending in state courts, including New Jersey, The claims brought against these manufacturers include personal injury for adherence, which is sticking to the internal tissue, bowel obstruction, infection, mesh failure, migration, perforation of organs or tissues, and seromas, which are pockets of fluid that require surgery. So the word on the street is that the hernia mesh cases will more than likely be more than the pelvic mesh cases. Right now we have 6,800 of them, which we are monitoring. So in addition to what Pamela spoke about, opioids, zantac, and hernia mesh are regrettably following the courses of other mass torts that have already seen significant verdicts. We'll see about that negotiation class and whether or not it takes any traction in the other mass torts. So there you go, Andy.
All right, thanks, Kelly. I want to move into future trends. I don't want to miss that part of the discussion. So, Sonia, one of the emerging trends I see in the news is our issues with supply chains. What have you seen in that regard?
In my opinion, it's our biggest concern for the future is the management of our supply chain for drugs, mostly generics, and to a much smaller extent, medical devices that are manufactured overseas. The first bullet of the PowerPoint refers to a common lethal problem in the third world, where a recent study showed that 7 out of 10 malaria drugs had no API or active pharmaceutical ingredient. Sadly, this is a story for a variety of drugs in the third world. Moving on to some of the contaminated issues, contaminated drugs are a serious problem in the U.S. In the U.S., over 90% of the drugs sold are generics. Over 80% of the generic drugs and or their API are manufactured internationally, mainly in China and India. In the first bullet under contaminated, I offer the example of heparin, a drug manufactured from pig's intestines that is used as broadly as a blood thinner. In 2008, various companies in China were intentionally adulterating heparin with oversulfonated chondroitin to mimic the high-potency heparin, which is produced at a higher cost. This intentional adulteration resulted in a number of deaths. Unfortunately, this is not the only event involving heparin. There was another heparin contamination in 2018. With respect to the NDMA contamination, that began in July of 2018 when the FDA announced that NDMA, a probable carcinogen in humans, had been found in the blood pressure medication valsartan, sold by 3 different companies in the U.S. but manufactured by Zhejiang Huaihai Pharmaceuticals in China. This is not the first indication of NDMA contamination. Test results found NDMA contamination as early as 2014. NDMA no longer has an industrial use, although it was previously an additive to rocket fuel. The NDMA recall has been expanded 51 times to include 2 related drugs, ibercitran and losatran, made by at least 10 companies in 30 countries. I should note that there is an MDL for cases involving contaminated valsartan in New Jersey. Since the initial recall of valsartan, there have been additional recalls of Zantac and similar drugs involving ranitidine, as well as metformin. Both Zantac, which Kelly described for you, and metformin are blockbuster drugs and heavily used. Both have been found to have the same carcinogen, NDMA. Recently, Xanax, an anti-anxiety drug, was subject to a recall due to contamination, although, interestingly enough, the company did not disclose the details regarding the contaminant. So what's the cause of this contamination? The most direct answer would be aging machinery, a lack of good GMP and quality control. A more long-term explanation would be that the generics business is lucrative and the demand remains very high. Profit margins are low when compared to brand name drugs, so cutting corners is an ever-present temptation. A second issue is the lack of oversight by the FDA. In 2006, the FDA had 3 offices in China. Only 1 remains. Less than 1% of the drugs imported overseas are inspected by the FDA. The FDA's position is that it expects self-policing by these companies, which is exactly what it did with Huawei. Unfortunately, Huawei did not self-police itself. Finally, the FDA put Huawei on an import alert in 2018, even though the NDMA contamination problems occurred as early as 2014.
Okay, Kelly, I wanted to have you touch base with us on another unfortunate area that's developing, which is black market and counterfeit medical devices. What can you tell us about that area?
as Sonia, Sonia just mentioned about the counterfeit black market of the drugs, and while medical devices are behind, thankfully, in the counterfeit, they've existed for decades and continue to escalate. Counterfeit medical devices and equipment enter the legitimate healthcare supply chain in many instances because the buyers are seeking the best price. This is an open invitation to counterfeiters to hit those lower price points with their fake goods. Thus, a growing market exists in large part due to low-cost medical equipment seekers. I want to just jump. The issues with the counterfeit and black market products, adverse health implications, you're not getting the product that you think you're getting. They're non-sterile, poor quality, unknown materials may be inappropriate for use. But it's really an international problem. I think the positive thing that I've seen in the literature is that, starting with the World Health Organization, they are on board. They've been on board with past reports identifying, it's one. I think it was 1 in 10 medical products in developing countries were substandard or falsified, and at upwards of 8% internationally. If you could just go to the next slide, Andy, please. So the statistics, this slide and then the next one, what you're going to see is the World Health Organization and the EU have, in May of 2020, if we'll just go to slide 39, because I know we're close on time and the slides will be available to everybody. I think what the important thing is the European Union medical device regulations, which are coming out in May of 2020, really stress how global this problem is and the collaboration between between countries. There's been collaboration between the UK and the United States. There has been World Health Organization operations to crack down on counterfeit goods. But the EU's new medical device regulations are looking to increase patient safety by making products more readily traceable. Among the requirements are significant implications for product labeling in all its forms. Some of them include product information published on the manufacturer's website, which must be kept up to date, unique device identification data uploaded into the EU database for all devices by May 26th of next year. The IFUs can now be provided in non-paper format. The device labeling must be provided electronically, and new symbols must be included on the label identifying the product as a medical device. I think that the takeaway is that the Pharmaceutical Medical Device Organization has to try to stay one step ahead of the counterfeiters, because at the end of the day, we have to keep our patients safe. With respect to dealing with the counterfeit and black market drugs and devices, there's two terms I want to make sure everybody's aware of, and that is the passive method and the active method. The passive method applies to the packaging. Medical devices usually have 3 levels of packaging: primary packaging, which is the pouch; secondary box, which is the product box; and finally the packaged into a shipper, where there will be multiple products stored in one package. To avoid counterfeiting, manufacturers can apply deterrents to each of the items of the packaging, whether it be the hologram, UV identification code, 2D barcode with unique numbering or serialization, or hidden text printed using security or magnetic link. These are not intended for an end-user check, but as a deterrent to the counterfeiter. The second is the active method. The active method includes a unique serial number or reference number printed on the product's packaging that it's unique to, and it can be used to define exactly who manufactured the item, where it was manufactured, and the county of origin. By way of example, if a shipment of a product with serial numbers assigned to the China market were scanned at a customer site in South America, this would be captured as a diverted product and flagged up to the manufacturer supplier according to engage and then investigate. So, it still becomes our responsibility to make sure that we do what needs to be done for positive product identification. Hopefully, if it serves as a deterrent, the counterfeiters will look to another industry as opposed to ours, which really has such a direct negative impact on the consumer, because it's usually life-saving products or life-saving pharmaceuticals. So The prevention, I think, is where we need to move. I think the EU is moving in the right direction, and continued collaboration between our federal agencies is going to help nip this in the bud. That's it.
Okay, thanks, Kelly. We've covered some future trends, but I want each of you to look into your crystal ball and give me what you think will be the next big thing. So we can start with Sonia.
Okay. My prediction, I predict that antibiotic overuse leading to drug-resistant bacteria is going to figure prominently in the next epidemic or pandemic. What is it? It's the ability of bacteria and other microorganisms to mutate and resist the effects of the antibiotic to which they were once sensitive to. An example would be when you go to the doctor and you're complaining about all these symptoms, he prescribes an antibiotic just to get you to stop complaining when he knows when an antibiotic isn't really going to help you when you have the cold or the flu. What you have done is actually triggered changes within your own immune system, and this type of medical behavior really contributes to the problem. The worst of these antibiotic-resistant drugs appears to be MRSA, methicillin-resistant Staph aureus, a superbug that does not respond to most antibiotics. MRSA kills, and there are many health institutions and hospitals that have a difficult time making their premises sterile or even treatment for MRSA often requires extended hospital stays, additional follow-up on doctor visits, and lastly, toxic alternatives for treatment. The silver lining is that when faced with this particular threat, our clients may spur the development for our clients of new antibiotics, but also equipment to stop the transmission of these bacteria. Additionally, we could use equipment to track the genetics of the specific the genetics of specific bacteria and genotype it so that we know exactly where the bacteria came from. I'd also say that this risk is prevalent in agriculture where antibiotics are widely used on cattle and poultry, so it's not going to be a specific human problem. It's also going to be a problem in agriculture.
Thank you, Sonia. Kelly, can you look into your crystal ball?
Yeah, so I think, and it's not because I'm always on a diet, but potentially addictive products such as sugar, high fructose corn syrup, and I would also throw in salt. There's currently class actions filed against Kellogg. The vaping epidemic from our youth all the way up through, adults that are trying to quit smoking. The fact that there's a lack of regulations, especially with the vaping products, I go back to 2016, which were the same that were used as tobacco. That leads me to the second big concern I have is, and it's on the next slide, is about big data and social media triggering more life science mass torts. So just some statistics. Between 2000 and 2017, approximately 30% of mass tort litigation was initiated before or independent of a major regulatory event. That might be, that's right. And then 2008 to 2018, it's now up to 72%. So what does that mean? In the past, we've seen an FDA recall, and then the FDA recall spurs or label change spurs civil litigation. Here, civil litigation is occurring before the FDA acts. So what happens is that the science isn't catching up to the lawsuit, and then what are we faced with? We're faced with junk science in the courtroom. I think that's a very, very big concern. And what happens is because of social media, it's because of big data. All of this is working hand in hand with the plaintiff's bar in gathering the clients, and it's really funneling the litigation. And I think that's what doesn't matter what the product is, if it's sugar, high fructose corn syrup, salt, antibiotics, zantac, you name it, big data and social media is really the driving force behind a lot of these lawsuits. And the ability to get to the consumer is just so much greater than it was when it was a big tobacco issue, that I think that's where we have to make sure, on the defense side, that we get the science out in front, because we have to turn that tide back and not get stuck with on our back heels trying to defeat this junk science. So that's one of my main concerns.
All right. Thank you, Kelly. And finally, Pamela.
Very quickly, I agree with Sonia and Kelly's predictions. I would throw into the mix first-party litigation from workers' comp and related claims on the opioid litigation, because we've seen that very tortured construct on a theory of nuisance that really is not nuisance as I was taught it in law school, and I think you're going to see a lot more claims of that nature using the nuisance theory to reclaim costs of drug addiction by municipalities and workers' comp claims that have, maybe occurred as a result of a drug addiction problem. I think you're going to see a possible spike in those trends. Certainly cannabis is a big ticket in my view, in conjunction with the trends in the vaping that we've seen. And lastly, the cybersecurity risk. I think we're seeing more and more of these medical devices that are dependent on internet and computer-driven programs, software, etc., will be victims of hijacking and cybersecurity. And I think we're going to see a lot more of that in the future, unfortunately. And more of the same with respect to all of the cases that are waiting in the wings until we have tort reform, or until America embraces the English rule. And dare I say that as an Irish person, but it's the one English rule that I think this country should embrace, and that's loser pays. We certainly need something to cap the tide of what are vicious verdicts.
Okay, thanks, Pamela. We have time for one question here, and I think Pamela probably actually is best at least directed to you initially. So in your slides about the verdicts, we saw a lot of the big awards, and some of those damage awards are actually reduced. How often does that happen, and is that something that's communicated as well to the public as the initial, say, $8 billion award?
I think that's an excellent question, and it certainly is a subject of post-judgment motions and usually up on appeal. The defense bar should, do a better job, I think, at publicizing that. Johnson & Johnson did issue a statement with respect to the reduction in their multi-billion-dollar verdict, but it still looks, I think, we could all do a better job, because it still looks a little like, so what, you got it reduced by, 76 million, you're still hitting a pretty large verdict there. Certainly, there's anything that is in excess of the Campbell State Farm Supreme Court decision, anything in the double digits is ripe for appeal. Usually most courts will use a 1 to 3 multiplier as being reasonable. 1 to 9, I think, is on the excessive side and certainly worthy of appeal. I do think it behooves us to challenge those excessive verdicts and not simply let plaintiffs have their say and splash all over the media. Kelly, what do you think?
I agree with that. I agree that was a great question, and I thought Sonia had made a comment earlier about perception, and I know that we as defense attorneys often look to make sure that the right hand knows what the left hand is doing, with Pamela being in San Francisco and I in the New York, New Jersey market, to make sure that if there's something good going on the East Coast, make sure my colleagues on the West Coast know that. And I think it's the same for our clients. We have to do a better job at conveying that to the public, because all they see are these big numbers, and the reduction is significant. The reduction then makes that underlying verdict a win, because we're in the business of trying to save people's lives. It's a very risky business, and that needs to be, we just need a better PR for it. And again, that goes back to the social media, that goes back to the big data. We have to get our story out there even after the fact, because it is an effort on the part of the defendant to get the judge to reduce those verdicts. And, they just don't do it willy-nilly. We have to make certain showings that are completely tied to the evidence. So, I think it's an effort for all of us collaboratively to make sure we get that message out there.
One point I wanted to make about Johnson & Johnson, they did attempt, I mentioned the geofencing. What that is it's positive advertising within a concentrated area where you think your jury pool is going to come from, but they did fall into something of, they got a bit of a reprimand from the judge in the case, although I think that type of activity needs to happen more often, as Kelly says, because we do have a great story to tell about the therapeutic benefits and the life-saving medicines that these people have come up with, and the benefit needs, the story of benefit needs to be equally supported in terms of the risks and the adverse verdicts that we're seeing.
Great points by everybody. That's all the time we have. I want to thank our panelists and thank everybody for attending our webinar.